of Mumbai drew a bill of exchange in Mumbai on B, a merchant in Mathura, and we accepted the bills of exchange as payable in London. It is also an inland bill of exchange. In this case, the bill of exchange was drawn in India on a person resident in India. It is immaterial that the amount is payable in London.
Checking. Yep, correct. It's inland because it's drawn in Mumbai on a person resident in Mathura. Payable in London doesn't change it. Your reading is odd on.
An inland instrument remains inland even if it is even if it has been endorsed in a foreign country. What does it mean? Could you explain me with an example as well?
Checking. Think of it like this. Once an instrument qualifies as inland, later endorsements abroad don't change that character. For example, A makes a promissory note in Kolkata, payable in Mumbai. That's inland. Then B goes to London and endorses it to C there. Even though that signature happened in London, the note stays an inland instrument because its nature was fixed by where it was made slash drawn and where it was payable, not by where later endorsements happen. So those later transfers don't flip it into a foreign instrument.
So when a certain someone draws a bills of exchange, let's say A draws a bills of exchange on B, and B accepts the bills of exchange payable in India, and let's say it was drawn in India as well, and it was accepted in India as well by B. Once it got accepted, I mean payable accepted. Uh, uh, what if the bills of exchange is being endorsed outside India to someone called John? John, does he has to come in India for that payment, or he can take from there itself?
Checking. John doesn't necessarily have to physically come to India, but since the bill is accepted as payable in India, payment has to be claimed in India. So practically, he'd usually collect through a bank or an agent in India. He can be the holder even if the endorsement happened abroad, but the place of payment stays where the bill says, in India. So he wouldn't personally need to travel if he uses a bank or representative.
So he needs a representative who will be accepting the payment within India. So it's not possible to pay outside India in such case.
Check. Right. If it's accepted as payable in India, payment has to be made in India, not elsewhere.
All right. The next is if the bills of exchange mentioned in above two examples are endorsed in France, they will remain inland bills.
Checking. Yes, exactly. Endorsement in France doesn't change their character, they remain inland. The place of endorsement doesn't alter inland status.
So, so a foreign instrument is a one which is not an inland instrument. In other words, it can be understood as follows: a place where the bills is drawn, it's to be outside the country. Am I audible? What about foreign instrument?
One second. A foreign instrument is simply any negotiable instrument that doesn't fit the inland test. So if it's drawn outside India, or it's drawn in India, but neither payable in India nor drawn on a person resident in India, it's foreign. For example, A bill drawn in London and payable in Mumbai is foreign because it wasn't drawn in India. Or, say, drawn in Mumbai on a merchant in New York and payable in London, also foreign because it's not drawn on a resident in India and not payable in India.
So liability of maker or drawer of foreign bill. In the absence of a contract to the country, the liability of the maker or the drawer of a foreign promissory note or bill of exchange or check is regulated in all essential matters by the law of the place where he made the instruments and the respective liabilities of the acceptor and endorser by the law of the place where the instrument is made payable. Give example.
Let me get that right. So, that rule is about which country's law governs each party's liability on a foreign instrument. For example, A draws a bill in New York on B, payable in Delhi. A's liability as drawer is governed by New York law, place of making. B's liability as acceptor is governed by Indian law, place of payment. Same for any endorser. Their liability is tied to the law of the place where it's payable. That's the basic split.
So, does it basically mean about the tax laws, or is there any other law that is applicable on such persons?
Check. No, this isn't mainly about tax laws. It's about substantive liability on the instrument. Things like who has to pay, to what extent, interest, damages, and conditions for enforcing that liability. Tax questions are a different regime that might arise separately, not what this section is talking about.
So, a bill of exchange is drawn by A in Berkeley, where the rate of interest is 15%, and accepted by B payable in Washington, where the rate of interest is 6%. The bill is endorsed in India and is dishonored. An action on the bill is brought against B in India. He is liable to pay interest at the rate 6% only, but is charged as a drawer. He is liable to pay interest at 15%.
Checking. Yup, that's the point. The acceptor's liability follows the law of the place where the bill is payable, here Washington at 6%. But A's liability as drawer follows the law where it was drawn, Berkeley at 15%.
What if the case is about a breach in the issuing of the negotiable instrument, uh, and the parties are from different nations? Which law applies?
Let me check. It depends on what kind of breach. For the core obligations on a foreign instrument, the NI Act splits it like this. The maker or drawer's liability by the law of the place where it was made or drawn, while the acceptor or endorser's liability by the law of the place where it's payable. Dishonor and notice are also tied to the law of the place of payment if it's different from the place of making or endorsement. So if the breach you're talking about is by the drawer in issuing it, generally the law of the place where it was issued or drawn applies.
No, let's
If it's
say,
about
let's
not-
say
Yeah.
a person issue a check to B A issue to B, and both are from different nations, and let's say B later on endorse that check to see who is from another nation. Later on, if the check got dishonored, C gonna sue on either B or A. So I'm asking who will take actions, which law will be applicable on the other two parties, and the level of punishment will be based on which nation law.
Checking. In your example, C is the one who takes action as the holder. He can proceed against A as drawer for dishonor. In India, criminal liability under Section 138 falls mainly on the drawer. A. Punishment is set by the law of the country where the offense is prosecuted, not simply by nationality. Civil liability depends on the conflict rules. The drawer's liability usually follows the law of the place of drawing, and the endorser's follows the law of the place of payment. And dishonor or notice often follows the law of the place of payment. If it's cross-border jurisdiction and exact penalties can get tricky. It's very fact specific.
So C has to go to the court in India.
One moment. Not always. It's not automatic. C goes to the court.
Your voice got cracked in the middle. Would you please repeat?
Sure. So it's not automatic. C would go to whichever court has jurisdiction. So say the check is drawn on an Indian bank or deposited via an Indian branch, then an Indian court may have jurisdiction. Otherwise, if it's drawn and dishonored abroad, then C might need to go to that country's court.
No, let's
It's
say
really about where the
let's say in the example A issued the check, and A issued the check in India,
right.
and
Okay.
B accepted the payment in
Mm-hmm.
America, let's say, and then
Yeah.
B endorses that check to C who is in Spain. Now that's that person C, when he went to endorse the, the check, it got dishonored, and in this case,
Mm.
where the person C will go for grievances.
Checking. In that setup, the case would most likely go to the court linked to the place of payment, which is America. Since C presented it there and it was dishonored there, for dishonor and notice, the law of the place of payment kicks in. A's liability as drawer may also be judged by where it was drawn, but practically C would sue in the jurisdiction connected to where the check was payable and dishonored, so likely America.
So, is there any such a real case?
Checking. There may be real cases, though that often looks like a textbook hypothetical. The NI Act itself illustrates the principle, and there are real cases on foreign bills, like Griffin versus Weatherby, but the exact A India, B America, C Spain is more of a made up scenario, unless your text cites a case name. The takeaway is the principle, not the exact names or places.
No, I asked about the similarities, not specifically ABC, but I asked where there is three nations or two nations is involved. Is there any such case law?
Yes, similar cases exist. For instance, Griffin versus Weatherby involved a bill drawn in the Isle of Man and payable in England. So, two jurisdictions. Indian courts have cited it when discussing foreign bills. There are also Indian cases with foreign parties, like one involving a Singapore entity. So, yes, the idea is real. Multi country instruments do end up in court.
Let's say a certain, this is a whole new different question. Let's say a certain
Okay.
government, let's say a government sues a company who was doing business in the country.
Yeah.
So
Okay.
the government will file the case in which country? In that specific country or the country where the entity is from?
Checking. Usually, if the business activity and the alleged legal violation happened in that government's country, then that's normally where the case is filed. The company's foreign nationality doesn't block local jurisdiction, but contracts, treaties, or arbitration clauses can change things.
Um, but what if uh, the entity stop operating in that country and goes to its original country? So is there any way to take actions against them?
Checking. Typically, yes, the government can still bring a case in its own courts, serve the company abroad, and then try to enforce the judgment in the company's home country. It can also attach any local assets the company has left and use treaties or cooperation for serious matters. So leaving the country doesn't automatically erase liability, but yes, enforcement can get more complicated.
But what if the country become an alien country?
Checking. If by alien country you mean just a foreign country, then yes, it's the same as
No,
what I just described.
let's say any dispute has been started between those two countries.
Checking. A simple political dispute doesn't automatically change the company's legal status. Only if there are sanctions, formal restrictions, or an actual state of war do alien enemy type restrictions kick in. Otherwise, courts and contracts usually still work as normal.
Yeah, let's say the dispute is about war. So what happens in such cases?
Checking. If it becomes a war, then the company could be treated as connected to an enemy country. In that case, contracts and lawsuits may be suspended or limited, and special government permissions might be needed. Ordinary enforcement routes can be restricted, and government to government or sanction based measures take over. So, the simple point is war changes the legal framework, and normal remedies can pause or be restricted.
When we take patent rights, uh, in which country do we have to register? Or I'm asking about any other intellectual property.
Check. For patents and most IP, you generally register in each country where you want protection. There isn't one worldwide patent. For multiple countries, you can file through systems like the PCT for patents or Madrid for trademarks, but those still lead to country by country protection in the end. Copyright's different. It arises automatically in most places, but enforcement still happens under each country's law.
So when there is a release of any film, do they previously manually go to each country for exclusive right, or is there any other way?
Checking. For films, they usually don't manually register copyright in every country. Copyright protection is automatic in most countries, but the actual release rights, like which company can distribute in each country or region, those are handled through contracts. So it's mainly private distribution deals rather than country by country copyright registration.
What is inchoate instrument? Which is,
Inchoate instrument
yeah, go on.
checking. One moment. It's basically an incomplete negotiable instrument. Under Section 20 of the Negotiable Instruments Act, if someone signs and hands over a stamped paper that's blank or incomplete, they give the holder authority to fill it in within limits. Simple example, A signs a stamped blank promissory note and gives it to B. B can fill in the amount within their authority.
So, inchoate instrument, it means an instrument that is incomplete in certain respects. The drawer or the maker or the acceptor or the endorser of a negotiable instrument may sign and deliver the instrument to another person in his capacity, leaving the instrument either wholly blank or wholly blank or having written on it the word incomplete.
Mhm.
Is it correct?
Checking. Almost, but not having written the word incomplete. It should be either wholly blank or has an incomplete negotiable instrument written on it. And by signing and delivering it, the person gives the holder prima facie authority to complete it as a negotiable instrument within the stamp limit. That's the core idea.
Such an instrument is called inchoate instrument. And this gives a power to its holder to make it complete by writing any amount, either within the limits specified therein or within the limits specified by the stamps affixed on it.
Checking. Yes, that's right, with one caveat. The amount filled cannot exceed the stamp value, and if the holder is not a holder in due course, they can't recover more than what was actually intended.
So,
So the
so
power
the,
is
the
broad.
principle of this rule of an inchoate instrument is based on the principle of estoppel. Here, what does estoppel mean?
Checking. Estoppel means that a person can't deny something when their own conduct made someone else believe and act on it. Here, if you sign and hand over a stamped blank paper, you can't later turn around and deny responsibility to a holder in due course because your own act enabled that situation. In simple words, you can't blow hot and cold at the same time. Once you've enabled the situation, you're bound to it against a bona fide holder.
Can you hear me?
Just checking the line.